persons having anything to do before the Honorable, the Justices of the Supreme Judicial Court, now sitting in Boston, with the for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is now open. Please be seated.
Let me just say for purposes of this record that Chief Justice Gantz is recused from this matter and that Justice Link is participating in this matter and is watching via the internet feed.
OE-0136 in the matter of Thomas Estes.
Good morning. May it please the court, my name is Howard Neff. I represent the Commission on Judicial Conduct in this matter. Today, this court is asked to decide the appropriate disposition for what I would suggest is egregious, willful misconduct by a judge that has seriously damaged public trust in the administration of justice in Massachusetts. This matter is without factual precedent in the history of complaints of judicial conduct in Massachusetts. And I respectfully suggest that unless this court sets a precedent that makes it absolutely clear that this type of conduct will not be tolerated, and that particularly with respect to judges, will be dealt with using the most severe discipline constitutionally available, there is little hope that public trust in the administration of justice in Massachusetts will be restored. In its brief, the Commission endeavored to provide this court with an explanation in support of its recommendation for disposition in this matter. In its brief, the Commission also endeavored to provide this court with examples of comparable misconduct in other jurisdictions. As the court may have noted, none of the cases cited by the Commission, or for that matter, by Mr. Hoos on behalf of Judge Estes, came from a jurisdiction that simply appoints its judges who then serve out a term. Only Massachusetts, Rhode Island, and New Hampshire enjoy that distinction. And I would respectfully suggest that in a jurisdiction like Massachusetts, where judicial conduct is not subject to review in the form of reappointment or election, there is a greater duty to ensure that judicial misconduct is fully and adequately addressed.
Much of the respondent's brief goes beyond the final submission under Rule 13. Mm-hmm. What do you think we do with that?
Well, I respectfully suggest that the court should not consider any content in the respondent's brief that exceeds the court's March 15th order, that it be restricted to facts agreed upon by the parties in the 13A submission itself. In the Commission's brief, as I said, we attempted to provide this court with an explanation in support of our recommendation for disposition in this matter, which I would suggest did confine itself to the four corners of the 13A submission. The Commission looked at cases of historical judicial misconduct considered by this court, looked at factors considered by this court historically in deciding what the appropriate discipline in a particular case was, and after reviewing this court's past cases of judicial misconduct, considered four factors in connection with its recommendation for disposition in this matter. The first of which is whether or not Judge Estes' misconduct brought undeserved discredit to the administration of justice in Massachusetts. The Commission's position is that Judge Estes' conduct unquestionably brought discredit to the administration of justice in Massachusetts. From November of 2016 through March of 2017, he engaged in an undisclosed sexual relationship with Ms. Tammy Cagle while she worked as a court clinician as part of the Pittsfield Drug Court over which he presided. Ms. Cagle participated in team discussions regarding whether or not people were good candidates for the Pittsfield Drug Court. She participated in team discussions regarding whether or not people facing probation violation proceedings continue to be good candidates for the Pittsfield Drug Court. She also had one-on-one conversations with Judge Estes about the general operation of the Pittsfield Drug Court before or after her sexual encounters with them.
Counsel,
Yes.
oh, go ahead.
No, please.
I was just going to go back for a minute to, you were talking about the, never in the history have you seen anything like this? And just to establish the fact that how the Judicial Conduct Commission operates, you take in a significant number of, well, I don't know if they're significant, but a number of complaints that the public never sees or hears about. And often, if my understanding is those are worked out on agreement, and the judge may frequently retire or resign without coming to this point, which is that why we have so few of these? Or is it because these facts are just so strongly different, so significantly different?
I would say the answer to that is that this case is, as this court knows, some complaints can be resolved by the commission through what we call an agreed disposition. An agreed disposition, as this court also knows, does not include discipline that is available under Section 8.4 of our enabling statute. I would characterize the discipline available under Section 8.4 of our enabling statute as more severe discipline that's appropriate for more serious complaints. And so, to answer your question, hopefully, the reason this complaint is before this court in this posture is because it is the view of the commission that none of the discipline that would have been available to it by way of agreed disposition is the appropriate disposition of this complaint, that only by either proceeding to formal hearing, et cetera, and then going before this court, or by the other mechanism available, which is Commission Rule 13, could this matter be adequately addressed by this court.
I understand. Thank you.
How important is the repetitive nature of the misconduct here to the commission? This wasn't a one-time incident.
I would suggest that it's very important. It goes to, as we pointed out in our brief, to a certain extent, it goes to the willful nature of Judge Estes' misconduct, which the commission considered as an aggravating factor in this case. As we point out in our brief, Judge Estes, by his own admission, the day after his first sexual encounter with Ms. Cagle in November of 2016, was racked with guilt, apparently appreciating that what he had just done was wrong, but instead of stop, he continued to have an ongoing sexual relationship with her for another 8 months, continually used on at least 3 occasions his judicial lobby in Belchertown District Court for those sexual encounters with Ms. Cagle, and finally used his judicial email repeatedly to either further his romantic relationship with Ms. Cagle or to at least in part arrange his sexual encounters with Ms. Cagle. So one example, or one contrary example I might point to the court, is the matter of Markey case, where this court suspended Judge Markey for essentially a single act of misconduct for 90 days. Here we don't have a one-time lapse in judgment, essentially, like in the Markey matter. Here we have a judge who did something wrong, knew what he did was wrong, and continued that pattern of conduct for another 8 months.
Under the agreed facts, the commission considered and did not find any judicial favoritism towards Ms. Cagle, correct?
There certainly was no direct evidence of favoritism toward Ms. Cagle in the commission's investigation of this matter, which is why, in part at least, I point the court in the direction of the holding in the Girard case from Iowa, which, to paraphrase it a little bit and quote from it otherwise, basically says that it is immaterial that the Judges Association may not have had a detrimental impact on the decision-making. The key concern is the appearance of impropriety. As this court well knows, judicial decision-making, judicial discretion is subtle, can be very nuanced, it's organic, does not necessarily lend itself well to direct evidence of undue influence. So I suggest that's why the standard is, under the circumstances, would a reasonable person infer that Judge Estes' decision-making in connection with the Pittsfield Drug Court over the period of time from November 2016 to March 2017 was subject to undue influence by Ms. Cagle because of this ongoing undisclosed sexual relationship she had with him while she was literally participating in team discussions potentially regarding the liberty of criminal defendants that were before that Pittsfield Drug Court.
Well, I'm not asking you to give us a hierarchy of the seriousness of the contentions here, but along those lines, the Rule 202 contention, that goes to the conversations about the drug court with Ms. Cagle that you were referencing previously. Is that correct?
Yes.
Yeah, and would you say that those discussions directly impact the issues of appearance of impartiality?
I would answer to you yes, and that's part of the point I'm trying to make, which is, you know, in this investigation, the complaint that we put before this court, I'm not going to say anything other than that there is no direct evidence that we found in our investigation that Ms. Cagle directly or that actually influenced Judge Estes' decision making, but judicial decision-making is subtle and nuanced, and who can say whether or not she had a subtle impact on his decision-making in one way or the other. But that's why the standard, I'd suggest, is once the relationship is known, once you realize that she has this ongoing sexual relationship with him, has his ear, is having conversations with him about the drug court before and after their sexual encounters, a reasonable person would infer, I'd suggest, that his decision-making in every single matter in the Pittsfield Drug Court for that period of time was subject to undue influence by Ms. Cagle.
Can you explain to the court the role that the court clinician plays in the drug court so that we understand what she did in the courtroom and and I think that will give some context to what you just answered.
Okay. Well, a court clinician's role as part of the drug court team is at a basic level to arrange treatment programs for various candidates, treatment beds, treatment programs for various candidates who are either in the drug court or being considered for the drug court. But part of the court clinician's role, and I'm not going to pretend it's the loudest voice in the room, but it is a voice that has the potential to persuade in one direction or the other. But part of the court clinician's role is to be part of a discussion regarding whether or not someone is a candidate for the drug court, meaning a criminal defendant. This is just a hypo, but potentially, to answer your question, criminal defendant could be facing charges in the district court, is a long-term drug offender, is being considered, instead of being sentenced like a normal criminal defendant facing a criminal charge of, let's say, breaking and entering, could be considered for the drug court as a nonviolent offender who has a drug problem. And entry into the drug court could be an alternative for that defendant to a long-term incarceration, meaning if you get into the drug court as a criminal defendant, the possibility is that you get a lesser sentence in jail or no sentence at all in jail as a consequence of your admission into the drug court. And that's the kind of conversation and decision-making a court clinician, including presumably Ms. Cagle, would participate in as part of the Pittsfield Drug Court.
If I could just go back again to the respondent's brief and pick up on two issues in the brief and see what your comment is. One has to do with judicial evaluations, Judge Estes' performance before these events and whether or not that provides any mitigation. And the other point to the brief seems to be there was no sexual harassment. Now, we have stipulated facts here, but that's palpable throughout the brief. So what do we do with those two issues?
Well, in terms of judicial evaluations, I mean, they're in there. The court can weigh them and give them whatever credit you see fit. Obviously, the commission in its brief indicated that it did not consider the judicial evaluations as a mitigating factor. And I would point this court to its own holding in the Markey case as a basis to really not consider that type of evidence in connection with the appropriate disposition. And in Markey, this court said, no amount of good behavior can negate the damage that misconduct inflicted on the judicial system, which depends on its institutional independence on the bedrock principle that all disputes coming before a judge should be decided solely on their merits, openly presented without extraneous influences. So here, analogously, what we have is a judge who has violated that bedrock principle. All of his decision-making in connection with that Pittsfield Drug Court over that period of time, I'd suggest, is subject to question. And therefore, I would suggest, by extension, that no amount of good behavior on the bench before this happened, around the time this happened, can negate the impact of his misconduct on the public's perception of the judiciary.
But I guess the question that I go back to earlier, and this is the point that Mr. Hoos raises, is, in quote, nor is there any evidence that the relationship had any impact on the functioning of the court. And what you're telling us is inherent in this relationship that they had would be an impact on what you call the subtle or organic decision-making of a judge. Isn't that kind of an amorphous standard that we're supposed to apply, where the commission looked specifically to see whether or not the court or his decision-making was compromised and found that it wasn't?
Well, I don't think that there's no evidence that Judge Estes' decision-making was influenced. I'd suggest that there's no direct evidence that his decision-making was influenced. I would suggest that what this court's been presented with are the results of an investigation that lends itself, that has presented ample evidence, credible evidence, clear evidence, convincing evidence, conclusive evidence, that would cause a reasonable person to infer that Judge Estes' decision-making in connection with the Pittsfield Drug Court during that period of time could have been influenced by Ms. Cagle because of his ongoing undisclosed sexual relationship.
No, correct me if I'm wrong, but is my memory from reading the record that there were text messages between them about a particular person in the drug court?
There were. That's true, Your Honor.
Okay, thanks.
Ms. Bristol.
Aaron Bristol, that's right.
And Judge Estes' decision was the opposite of what the discussions in the text from Ms. Cagle were requested.
That's apparently what happened. That's true.
So your recommendation for indefinite suspension is not based at all on whether there was actual influence it's enough that he abused his position in a variety of different ways. Is that right?
I would agree with that, yes.
And you also don't resolve the harassment issue in your, and again, so we don't need to resolve the harassment issue, in your view, in order to order indefinite suspension. Is that correct, too?
Well, what I would say to Your Honor is this court has in some form or fashion been presented with all of the evidence the commission gathered in connection with its investigation of this matter. As Mr. Hoos points out in his brief, Ms. Cagle was not well-liked or well-received by the probation department in the Pittsfield District Court. Judge Estes, to a certain extent, came to her defense in her relationship with the probation department in the Pittsfield District Court. Ms. Cagle did send text messages and emails to Judge Estes that, at least in part, sought out additional sexual encounters with Judge Estes. In light of those circumstances, in light of the enormous power disparity between Judge Estes and Ms. Cagle, did she feel she had to accede to that relationship? Did she feel, to a certain extent, she even had to pursue that relationship? Did Judge Estes, by at least participating in that relationship, if not pursuing that relationship, engage in some form of sexual harassment? What the commission was presented with and has presented now to this court is not a clear, straightforward case of sexual harassment or fact pattern relating to sexual harassment, like, for instance, in the Willoughby case that Mr. Hoos cited. But I would respectfully suggest Judge Estes' conduct, the evidence before this court, the conduct Judge Estes has admitted to is so far over the line that this court doesn't need to reach those questions to conclude that the only appropriate disposition for this matter is the disposition that has been recommended to this court by the commission.
Let me go back to what you initially said, in that this court has a greater duty to discipline because our judges are appointed, and we're not answerable to the people via the vote. Of course, there's no precedent for that proposition. That's just what you argue follows from our judicial system?
I would say, at least in part.
Or is there precedent for that?
But, well, there's certainly no precedent that says that, and maybe the court could take this opportunity to make that precedent. But what is implicit in at least some of the cases that both Mr. Hoos and I have presented to this court is those other jurisdictions, when they impose sanctions on judges for what we coined as comparable misconduct to what's presented to this court, you can see them considering, in connection with what they think is the appropriate disposition, the fact that there's an upcoming election. In fact, in the Wolfong case that I kind of focused on for the court in the commission's brief, Judge Wolfong, the West Virginia Commission actually recommended that he be suspended for 3 years. The West Virginia Supreme Court actually reduced that to 2 years, and when it did so, it said, we're going to suspend this judge for 2 years in deference to the fact that we want this judge to be we don't want this judge to be suspended beyond the next election cycle so that the voters can decide whether or not this judge should continue in service. And there are a couple other cases that have been cited that similarly at least consider the fact of upcoming elections in connection with what the appropriate disposition of those complaints were. For instance,
But we don't have the last say here anyway. The legislature or the governor's office has a role comparable to the election process, doesn't it? So
that's true, and we hopefully didn't mince words in our brief. The recommendation of the commission was basically adopted or taken from this court's own decision in matter of bond and in some other cases with similar language, which is clearly this court has made a decision that constitutionally it's not within the authority of either the office I work for or this body to remove a judge from office. And the truth of the matter is, for all practical purposes, the difference between the commission's recommendation for disposition and the recommendation on behalf of Judge Estes isn't that huge. They both involve
Can I ask you one particular question? Do you ask for, the commission also recommends that in connection with this disposition, the court grant the commission permission to share information and evidence from its investigation in this matter. You don't have that right without us providing it to you, or do you?
I'm not sure it's clear that we do. I think anything that's part of the public record at this point is fair game. But for instance, one thing that's alluded to in Mr. Hoos's brief is witness statements that we took. whether those belonged in submission to the court, who's to say, but maybe that would turn out to be relevant in
I mean,
a particular way.
including Ms. Cagle's witness statement.
Well, Ms. Cagle and honestly, quite a few witnesses were interviewed in connection with this investigation. So who knows? And I don't mean to be limiting in any way. There could be other evidence. Indeed, there were other text messages that never became part of any submission to this court or as part of the statement of allegations. So.
Attorney Neff, in your experience doing this and dealing with matters involving judges from other different kinds of courts, do you see anything inherent in the nature of a drug court or other kind of specialty court where all the members who are involved are trying to work as a team and sort of less in the adversarial process than might be traditional, and maybe there's less of an arm's length distance between a judge and a member who's appearing in front of them or working in the court? Do you see a difference there, or is that not relevant to this?
No, I would say that's relevant to this, and I'll speak a little from my own professional experience, which is beyond the commission. I worked as part of a drug court team for about 3 years in what was then the Brighton District Court, and my experience there was it was collegial, and people worked as a team and got along and were really trying very hard to work toward successful treatment results. But the presiding judge in that court was very careful about what was discussed in that room and what was not discussed. Even with everyone present, was very careful about what was and was not discussed in that particular room. And I'll admit this was well before the new Code of Judicial Conduct that became effective in January of 2016. But collegial, yes. Professional, yes. But the judge maintained that professional distance in certain subjects, like whether or not someone was going to be potentially taken into custody or subject to a probation detention hearing during an upcoming drug court session. Those sorts of conversations, the judge who presided over that drug court would defer to open court when everyone was present.
Mr. Neff, I'd like to go back to your answer to Justice Kafker's question.
Mm-hmm.
So, because I'm not sure it was clear to me, are you saying that this court should take into account sexual harassment allegations because of the different positions of power between the judge and Ms. Cagle? Or are you saying, no, based on the stipulation in Rule 13, we should not consider any contention of sexual harassment at all?
Well, I'm trying to answer that. The commission, in its Rule 13 submission, and as you probably saw in its statement of allegations, made no conclusions or suggested no conclusions one way or the other, whether this was sexual harassment or wasn't. And I don't want to suggest or leave any inference that the commission made a determination that this was not sexual harassment.
I appreciate that. I'm just asking because we're about to hear from the respondent.
Right.
The first 10 minutes of the argument is about there being no sexual harassment. We'll listen to 10 minutes of a position that you're going to tell us does or doesn't matter.
Yeah, the Rule 13 submission, I'm not going to mince words about it. It does not suggest that Judge Estes should be disciplined for sexual harassment.
First 10 minutes of the argument from the respondent is about there's no sexual harassment. Your view is that's of no importance.
That is not part of the basis for the commission's recommendation for disposition in this matter.
Okay.
That's true. So what I would say I guess with the red light conclude a little bit is the commission did its best to provide this court with an explanation in support of its recommendation for disposition in this matter, cited factors based on prior cases considered by this court, also made its best effort to provide this court with comparable cases of misconduct from other jurisdictions, although as I indicated, I'd suggest because of the difference in the appointment and retention process in Massachusetts, those cases are of limited value. So what I would respectfully suggest is that this case really does boil down to a simple question, which is, in light of the seriousness and nature of Judge Estes' misconduct, conduct he has admitted to, conduct that is part of this 13A document, does this court believe that he can ever command the moral authority and respect necessary to be a judge in Massachusetts? Or has he, through his conduct, rendered himself permanently unable to do so? I'd respectfully suggest that he can never command the moral authority or respect necessary to be a judge in Massachusetts. The public will never trust the administration of justice in his courtroom again, and the only appropriate disposition is for this court to adopt the commission's recommendation in this case.
Okay. May I have one last question?
Sure.
And that is, with regard to what you just stated, with regard to Judge Estes, to what extent do you think we should be concerned with not just whether Judge Estes is viewed as having the moral authority to act as a judge, but that the entire judiciary has the moral authority to act in its own capacity?
Well, I think that's a concern. Quite honestly, I agree. I think the problem is maybe a little greater, which is not only will the public not necessarily trust the administration of justice in Judge Estes' courtroom if the court does not adopt our recommendation, but indeed the public, to a degree at least, will not trust the administration of justice of the judiciary in general as long as he is allowed to wear a robe in Massachusetts.
Any further questions? Thank you, Mr. Neff.
All right, thank you.
Mr. Hoos?
Good morning. May it please the court, David Hoos for the respondent, Thomas Estes. As often happens when you come here as the respondent, I think I'm going to throw away my notes and get right to the question that Justice Lowy has, if I could get the microphone fixed, I would do that anyway. Has posed to the court, and that was the first question that Justice Lowy asked, is that much of my brief goes, in your view, beyond the Rule 13a submission. This process of getting here was awkward and difficult, and I can tell you that Mr. Neff and I had many conversations about what the appropriate role was of the commission here, what facts needed to be found. Now, Justice Kafker has injected into this, well, what are we supposed to do with what I say is the white elephant in the room here, the allegation of sexual harassment, which we contend is completely baseless and without merit. And the back and forth that Mr. Neff and I had, and I'll interject here that it was always cordial and professional, was that we're not dealing with that. That's for another court to deal with. We're not dealing with the allegation of sexual harassment. So while I was okay with that to a certain point, to a certain degree, it still is the elephant in the room. And the allegations kind of wash over into the allegations that are before this court, most particularly the ones that Justice Gaziano has correctly identified here today, meaning the allegation of whether there was any actual impropriety. Now, to give you an example of one of the, and let me just back up and say that one of the reasons that we agreed ultimately to a Rule 13a disposition in this court, there were numerous reasons, some of them just very practical, the cost, the time, the expense of a full hearing, was because I was assured that in the 13a process, the attachments to the submission would be viewed as part of the record and fair comment in brief and argument. And that's why, one of the reasons, main reasons, why we agreed to go this route. But to focus in on one of the issues in terms of what is correctly before this court, again, going back to Justice Gaziano's question as to whether there were was any actual impropriety.
I'm sorry, you've said that twice. You're not arguing that there was no actual impropriety here, are you?
Well, I think that when I use the term actual impropriety, I'm using it not in the primary sense. Obviously, engaging in a sexual activity with a coworker in his lobby, that is obviously impropriety. The question is whether, and when I'm using that term, I'm using it as many of the cases use the term, as to whether it created an appearance of impropriety in terms of the work of the court. Mr. Neff has talked about his view, both in his brief and again here today, that his relationship, which of course was unknown to everyone, tainted every decision that Justice Estes participated in. I think Justice Seifer asked a point, made a very good point, which is that drug courts are very much unlike other courts. Everything, especially in Justice Estes' court, was done in a collaborative manner. All the decisions were reached. As a matter of fact, I think it's in the record, he said that he could not recall a decision that was not reached by consensus, by everyone who was present in the courtroom. But in any event, to turn back to Justice Budd's question, I'm talking about impropriety, the kind of impropriety that actually affects decision-making in the courtroom.
But it's the appearance of impropriety that usually the focus is on, and this becomes known to everyone. Very little remains secret in courthouses, and this became known to the world. So now we have an appearance issue and an abuse of power issue
Well,
that even if it didn't directly impact individual decisions, places the integrity of the process itself at issue, doesn't it?
no question, Justice Kafker. Justice Estes has never denied that. I want to be clear on that because it was an issue that came up in the commission, too, which was essentially, you don't seem to understand the appearance of impropriety. We do understand the appearance of impropriety, but there are cases out there that are cited in my brief, and one of them is the Brown decision from the Michigan Supreme Court. I think another one is Deming from the Washington Supreme Court, that correctly point out that one of the factors that a court should consider in terms of the severity of a sanction imposed is whether there was actual impropriety as opposed to the appearance of impropriety. Now, Mr. Neff did his job here, and he went and spoke to every single person involved in that drug court, and he asked them all the same question. And I asked the commission to make this a part of the record, to make findings. And I was told that they would not agree to make this a part of the record, and that if we went to hearing, they would oppose a hearing officer making findings on these points. But the fact of the matter is, and it's in the materials appended to the 13A, is that every single person who was spoken to said they could not recall a single incident where it appeared that Justice Estes was favoring the position of Ms. Cagle. And I would point out that one of the great ironies of this case is, in my view, one of the reasons that we're here is because he didn't favor the view of Ms. Cagle. If he were favoring her views during discussions of people getting in and out of the drug court program, one would certainly expect that he would have taken some action when she was summarily removed from the court, an action that he had no part in, but prior to was asked what his opinion was of her without telling him that they were thinking of removing her. He gave an honest answer. She's a good clinician, but she can't get along with anybody, which was exactly what every person that Mr. Neff spoke to said. Not the good clinician part, but they all said, we can't get along with her. We can't work with her. I think that there was an expectation, or there certainly would have been an expectation, that if he were favoring her, he would have had the opportunity to intervene.
Well, let me ask you, do you think that the fact that people perceived her as difficult to work with was in part brought about by her perception that she could go a little further or do a few more things than a court, or say things or be more difficult than perhaps another court clinician might be who wasn't in a special relationship with the judge?
Well, I have no way of knowing what Ms. Cagle thought. I would simply suggest that I don't believe that there is any evidence of that in the investigation. I think that the evidence is very clear, and I'm not sure I'm answering your question here, but I think the evidence is very clear that Ms. Cagle knew that Judge Estes had no say over her placement or employment in that court. And indeed, when she was removed, she didn't go to Judge Estes and say, you need to do something about this, aren't you going to stand up for me? And the reason she didn't do that is obvious, because she knew it wasn't his call, and in fact relied upon him as a reference for her next job.
Can you address Attorney Neff's argument that, or his analysis that because we are a jurisdiction where judges are appointed and there's not an election, and we're not subject to an election to retain our position, and we are not subject to reappointment proceedings, that as a result of that, we must take the discipline very much more seriously, perhaps, than maybe another jurisdiction might.
Well, I think that that is all speculative, unfortunately, because, for example, in the Wilfong case that Justice Neff, I just gave him a promotion, that Mr. Neff cited, he pointed out that they reduced the term of suspension in the way I read the decision, to permit the voters to have a say. In other words, to allow her to run for re-election. Whether she was re-elected or not, I don't know. And one of the many factors we don't know, and the reason I answered the question, Justice Seifert's question the way I did, is because we don't know how many of these people were ultimately retained or re-elected to their seat, despite the allegations against them.
Mr. Hoos?
Yes.
Mr. Neff left us with the question, how can Judge Estes ever command moral respect or authority in the courtroom again? And I'd like to see if you could respond to that.
I'm happy to answer that question, Justice Budd. And the way I'll answer the question is this. First of all, there have been many sinners in the workplace generally. This is not the first. He is not the first person to have a sexual relationship with a coworker. He's not the first judge, male or female, to have a sexual relationship with a coworker. My brief cites many cases from around the country where justices engaged in sexual relationships with coworkers. Many of them were consensual. Some of them were clearly, in my judgment, sexual harassment. The ones where people were actually removed were few and far between. Many people got nothing more than a censure and were allowed to remain on the court. Now, that...
But judges are held to, I mean, they're the highest officers of the court, right?
Right.
They're held to the highest standards. And you know, whenever the person in charge of an organization is having a sexual relationship with someone who reports to them, that creates all kinds of problems, right?
Absolutely, Judge. And again, to circle back, there is no question here that Judge Estes is worthy, has engaged in conduct that is worthy of sanction. We have never denied that. The question here is whether it is sufficient to terminate his career. And with that, I most vigorously suggest that it is not. So let me answer now Justice Budd's question without reference to other states, but with reference to this state. This court dealt in the matter of Justice Killam, who was convicted of operating under the influence of alcohol. He was a district court judge. I don't know that anybody said, how can anybody trust him? How can anybody look up to him again?
Was he driving in the courthouse?
Was he driving at the courthouse? No, he was not at the courthouse. But this court has, with the matter of Justice Larkin, Justice Larkin tried to engage, send money to the governor. The court, in its opinion, noted that it violated several criminal statutes. He was never prosecuted. No one, he got nothing more than a censure. No one said that he no longer had the moral authority.
Did he resign, do you know, after that?
I do not recall, to be honest with you, Justice Seifert.
Mr. Hoos, let me ask you about more recent history in this state. In 2013, we decided in the matter of Clerk Magistrate Robert Powers, and that was a clerk magistrate who was removed from office due to lack of decorum, that he was intemperate while conducting clerk hearings, and because he was late, he would show up at 9:45, 10:15 in the morning, and he was tardy in issuing opinions. We looked at the public good and whether the integrity of the judicial system would be impaired by having Clerk Powers maintain his office. and we decided that he should be removed from office. And as you appropriately recognized, the judge sits at the top of the pyramid in a courthouse. We removed Clerk Powers. Where does that decision take us in relation to your client?
Well, I think that where it should take it, let me answer the question this way. If there were evidence that Justice Estes' conduct after hours in the courthouse with Ms. Cagle affected his abilities on the bench, affected decisions on the bench, affected whether he showed up on time, affected all of those things that you just outlined that Clerk Magistrate Powers, we would be in a very different position here.
But wouldn't you say a clerk would sit there and say, they removed a clerk because he was rude and late? Now we have a judge who's engaged in this conduct. What does that say about the judiciary and where we would hold ourselves vis-a-vis other personnel in the courtroom?
Well, I think that what it says is that conduct outside the courtroom and conduct that is beyond that which directly affects the administration of justice will be looked at differently. It should be, and it is a differentiating factor here. There have been a number of judges around the country, and again, I don't know how much weight this court is going to give to decisions from around the country. I would urge you to just peruse those opinions, because in almost every one, the conduct complained of is far worse than what Judge Estes has done. And in almost every case, they keep their job. So again, I think that there is a difference in the two cases that I would urge you to look at most carefully are the Brown decision and the Deming decision, one from Michigan and one from Washington. And I say that because they both sort of lay out a template as to how you decide these things. And as a matter of fact, the Brown opinion was written basically as a complaint, because they said, we get these things from the judicial retention or whatever they call it in Michigan. And they said, we don't see any evidence that there's a process here. And this is the process. They lay out some of the things that are important. And indeed, one of the most important things is, has there been an actual effect on the administration of justice? Is there actual impropriety as opposed to the appearance of impropriety? So here, while Justice Estes concedes that there is clearly has created an appearance of impropriety, there is no actual impropriety. And if I can just have a minute.
Well, there's actual, I mean, back to Justice Budd's point earlier, there is actual impropriety.
Right.
The question is, did the impropriety alter a judicial result in some way, right?
That's correct. And when I say that, again, I apologize. I guess I'm not being very artful in the way I convey that. But when I say impropriety, I'm conceding the primary impropriety without question.
We're taking that as a term of art.
Am I correct that as I was trying to count them up, there are about 11 code violations, canons of ethics that Judge Estes agrees that he violated?
Well,
Is that
yes. I'm going to say yes with an asterisk, Justice Cipher, because again, in order to get this case resolved, we had some very intense back and forths on whether or not certain code provisions were violated by this conduct. Frankly, I didn't think the conduct is what it is. I didn't think that it was going to matter to this court whether there were 8 violations or 6 violations, and as a practical matter, that we were going to have to go to hearing to argue over whether 2 violations were met out on facts that everybody agreed upon once it became clear that Mr. Neff and the commission were not insisting on facts that suggested sexual harassment. So I would just
push back on one other issue, which is I'm wrestling with. So unlike in the military, we don't have an ability to demote to demote for conduct unbecoming an officer. He can't be put back.
Right.
So, I mean, so we're left, with sort of conduct unbecoming the highest officer in the court. And, it's very difficult to sort of restore him to that position, isn't it? I just keep coming back to that. We can't demote him. We have to discipline him or discharge him, right? And we also don't even have the ultimate say in this, right?
That's right. And what I would say is this court has only on 3 occasions suspended someone and referred the matter to the governor for action. DeSaulnier and Troy, those cases are outliers in the sense that these guys were essentially crooks. The evidence of misconduct and unethical behavior was overwhelming. They were not cooperative. Justice Bonin's case was a little more nuanced, but still very clear impact on the administration of justice.
But use Justice Bonin's for a second, because using your own test of whether there's an effect on the judicial result there isn't, right? It's not clear that Bonin's misconduct had any effect on an actual case, right?
On an actual case, I think that's correct. I would say, however, that the problem of appearing on a partisan of a partisan taint to the cases that were then before the Superior Court was problematic. For my mind, what was more problematic in Justice Bonin's behavior was the hiring of the friends, which, again, I thought this court was quite genteel to him in referring to that as an appearance of impropriety. That, to me, was actual impropriety. You're hiring friends of litigants. I don't recall the exact facts. But to move beyond those 3 cases, the only 3 times where this court has asked the legislature or the governor to take action, all of the judges that I have mentioned, or at least that I started mentioning before, Justice Killam, Justice Larkin, Justice King, who engaged in publicly drunken behavior, public urination, racist behavior, judges who have repeatedly violated the law, even after they knew they were violating the law. I'm referring to Judge Scott, Judge King, Judge Donahue, Judge Markey, who attempted to interfere in a disposition in a probate matter. None of those judges lost their careers. And in fact, the sanction that we propose of 4 months, and this gets back to Justice Kafker's question as to what we can do. There are lots of things you can do, and they are touched upon in all of the opinions that I just referenced. The penalty that we propose is greater than any other penalty that this court has ever imposed, short of the cases of DeSaulnier, Troy, and Bonin, which I contend are not reasonably comparable to Judge Estes' conduct. So I think that the court can, you don't have the power to demote. You do have the power to strip him of his presiding judgeship, which he has already lost. You do have the power to suspend. You do have the power to assign him to different areas. You do have the power to bar him from specialty courts. You do have the power to do all these things, and all of these things are penalties, sanctions that are appropriate under the circumstances and would be willingly accepted by Justice Judge Estes. If I could just have a minute to wrap up here, I realize I'm significantly over. This court and all the courts that deal with these matters all say the same thing, that the purpose of these proceedings is not to punish the judge, it's to restore public confidence. I don't think anyone disagrees with that. Every single case, no matter how it turns out, talks about the importance of considering factors in mitigation. Some of the factors in mitigation that are present in this case and that are touched on in virtually every opinion are that the case involved no impropriety in an official capacity or no dishonesty, no effect on the administration of justice as opposed to appearance of impropriety. Justice has already suffered the consequences, including public humiliation and loss of status. Reputation of the judge is touched on in every single opinion in this court and in every other court, yet in none of them do you have the objective knowledge of what kind of Judge Estes is that is provided by the judicial evaluations that are before this court. Every judge in this Commonwealth, with the exception of a very small handful, would be happy to swap their evaluations with Judge Estes. He is not only a good judge, he is a superlative judge. He is an exemplary judge who has sinned, but he has not sinned so severely as it should cost him his career. I thank you very much.
Thank you, Mr. Hoos.
Court, all rise. Hear ye, hear ye, hear ye. All persons having anything further to do before the Honorable, the Justices of the Supreme Judicial Court, now sitting at Boston, within and for the Commonwealth. At present depart, the sitting of this court is now adjourned.